3 minutes.
Mr. Chairman, this amendment deals with the Commodity Futures Trading Commission and an issue that was raised on legislation that was on the House floor yesterday. Had a pretty significant bipartisan vote, I think a 301 to 124 with 73 Democrats supporting legislation that dealt with this topic. This is a much more toned-down version of that debate, and I know there are members of this committee who had passionate viewpoints on this topic. Essentially, under Dodd-Frank, the CFTC has been given additional responsibilities, as well as the SEC, to promulgate rules and regulations related to cross-border swaps. And there's a significant debate that was had on the House floor yesterday regarding how these swaps affect American companies that do business in global markets. And that debate, part of it deals with whether there's a presumption of compliance or whether the United States Dodd-Frank rules would apply in every foreign jurisdiction. And there's been a big debate about that. This amendment does not deal with that specific debate. All this amendment does is it asks the SEC and the CFTC to work together to promulgate similar rules jointly, and it asks the CFTC, when we finance this process, that they promulgate rules following the Administrative Procedures Act, essentially keeping the intent of those who supported Dodd-Frank, and is consistent with Dodd-Frank's request that the mandates are coordinated and that the Administrative Procedures Act is followed. Now, there's considerable uncertainty right now in global markets because of these rules and guidances going forward. The SEC has put forward rules, and they are taking public comment. The CFTC instead has actually issued a guidance. That guidance does not have a formal comment process. That guidance does not have the same legal protections as a rule, and that guidance does not do a cost-benefit analysis. Well, I believe the CFTC ought to do a rule just like the SEC does, issuing a guidance in this matter that is such a serious, important matter, creates global uncertainty, and it puts American consumers at risk, thereby defeating and diffusing the original intent of those who supported Dodd-Frank. And so I think this is the type of amendment that we could jointly agree would create more certainty for American consumers, American companies, clients, and would create a harmony and a coordination between the SEC and the CFTC. And let me give you an example of why this is so important. The SEC and the CFTC, which are regulating the same things, two different entities, they define person differently. How can we have two regulatory bodies defining what is a U.S. person differently? It's very challenging for the folks who deal in these areas, and it's very challenging for rules that may affect global markets. And so essentially what this amendment does in two parts is ask the CFTC to follow the same rulemaking process the SEC is following, which was following the Administrative Procedures Act, and it requires the SEC and CFTC to coordinate and to jointly promulgate the rules and regulations on this topic. With that, Mr. Chairman, I yield back.
Chairman Adderholt.
Yes, Mr. Chairman, thank you. We would support the amendment by the gentleman from Kansas. As he pointed out, there was a vote yesterday on the floor. It received a very strong vote, a very strong bipartisan vote. This is an issue that needs to be addressed, and I appreciate the gentleman for bringing it to our attention, and we would support the amendment.
Mr. Farr.
Well, I'm sorry, maybe good intentions here, but I think it's a dangerous amendment, and essentially it exempts foreign banks and all those others from having to provide by the rules of Dodd-Frank, because you now say that none of those rules can take effect until they are jointly promulgated by the Securities and Exchange Commission and the Commodity Futures Trading Commission together. Do you know how long it would take to get those rules? I mean, so you're exempting people we want to follow American rules, saying you abide by, you're going to play in this field, you got to abide by our rules, and now I think you're exempting them from all of that, because the jointly process takes a long, long time. I cannot support this amendment.
Is there further discussion?
Mr. Chairman.
Mr. Serrata.
Mr. Chairman, I think we have to understand what this amendment is. This is part of those amendments that show up every so often to try to do away with that which is already law. There are still some folks in this Congress who can't get used to the fact that Dodd-Frank exists. Just like you will see on many committees attempts to do away with the Health Care Act because some people are just not happy with it. Now, I suspect that this particular amendment may show up also at the Financial Services Committee, since the gentleman is a member of that subcommittee, and we'll have to deal with it there. But I think the clear point here that has to be made is that these are attempts to water down existing law. Dodd-Frank is the law of the land. This is just an attempt to water it down. And as has been pointed out by Mr. Farr, it is a dangerous amendment in the sense that it exempts people that we should probably be supervising more than other people. And so it's just an opposite of what it does. And it may sound good because, in all honesty, it's a very complicated issue, and I'm not suggesting people don't understand it, but because it is a complicated issue, it may sound good, but this is not an amendment we should be supporting, not here or in the Financial Services Committee when it comes up later.
Is there further discussion? Mr. Crenshaw.
Let me speak in favor of this. I chair the Financial Services Subcommittee. Toronto's on that. And all this does is it's like common sense. Dodd-Frank says we're going to regulate over-the-counter derivatives. And derivatives are these complicated instruments, and they're a trillion-dollar industry, happens all around the world. And Dodd-Frank went on to further say there are going to be rules written by the SEC and written by this other agency, the Commodity Futures Trading Commission. So you got two agencies, and you would think the two agencies are going to write rules to regulate one area of law. They would coordinate that. In fact, Mary Jo White came before our subcommittee, the new chairman of the SEC. She said, we're working together. We anticipated this problem. She said, we're working to coordinate that. Secretary of the Treasury, Mr. Stu, came before our subcommittee. He said, we're working to coordinate that. Well, obviously, they didn't coordinate that. You got two different rules regulating the same issue. Now, how do you know how to comply with that? And all this amendment says is, if you're going to write those rules, write them together. Common sense.
Ms. Capter.
Yes. Mr. Chairman, members of the committee, this is a fascinating amendment, and I hope everyone has a copy of it. Even if you didn't know what the amendment was about, we've all lived the recent history of this country and the damage, the extraordinary damage that has been done to the American people, and then the damage from our country affecting countries around the world. We still aren't out of it. And what was at the basis of it? Derivatives, which nobody here has ever traded. Am I right? You've never been involved in overpricing them. You've never worked in those non-transparent markets. But every single community you represent, everybody's lost property value. What was done to this country was the greatest crisis of capitalism when that market fell in 2008 that we have lived through in modern history. So now we have this little innocent amendment proposed here that sort of says, well, you know, none of the funds may be used to promulgate rules regarding the extraterritorial application of the swaps provisions of the Commodity Exchange Act. Now, why do we have a Commodity Exchange Act at all? Because you know what? Greed has no limit. It is one of the ugliest dimensions of human existence, and they took communities down. They took millions of Americans down. So I find it interesting who's standing up and proposing that we be light-fingered on the derivatives industry when they are controlled by very few of the most powerful financial institutions in this country that are not accountable. Some would even say they own members of this Congress. No, I wouldn't say that. But I sure think it. And I'll tell you, we've experienced the largest transfer of wealth from Main Street to Wall Street in modern history. To even stand up in the Appropriations Committee and propose anything like this flies in the face of recent experience. Have you been awake? Now, why would we have a Securities and Exchange Commission and a Commodity Futures Trading Commission? Because securities are different than derivatives. They're different than futures. And they've taken this country down, and the people of this country, the people that I represent in Ohio, the losses they've experienced and still experience. This amendment is so ill-suited to this committee. It is ill-timed. It doesn't deserve our vote. And I hope the American people are listening to what's happening here, because these are industries that demand regulation. They demand oversight, and they don't demand more advocacy in this Congress by those who I fear do not realize what they are proposing. I would urge defeat of this amendment.
Is there further discussion? Hearing none, Mr. Yoder is recognized for a minute to close.
Thank you, Mr. Chairman. Unfortunately, some of the comments really had nothing to do with the amendment that's being proposed today, but they were interesting nonetheless. The harsher version of this topic, which has many more debatable points from the opposition to it, was debated on the House floor. It got 301 votes yesterday, including 73 Democrats. So the gentlelady's comments would really apply directly to many folks in our own party, so it's very interesting. But that being said, this legislation is very, very simple, and it creates clarity. And in fact, if you agree with the comments from the gentlelady or agree with some of the other comments, you still should like this bill, because all this legislation does is try to create clarity for folks that we want to be able to respond to what are apparently very important Dodd-Frank regulations, as have been articulated by others this morning. Those regulations cannot be responded to when we have two separate entities going two separate directions. Defining U.S. person differently, how could you operate? What's happening here is actually bad for consumers. We're not going to tell the CFTC and the SEC what to do. We're going to let them sort it out. All we're saying is they need to coordinate and jointly promulgate these rules, and we need the CFTC to follow the Administrative Procedures Act, which is actually required by Dodd-Frank. And with that, Mr. Chairman, I yield back. Thank you.
On the Yoder amendment, all in favor say aye.
Aye.
All opposed say no.
No.
The ayes seem to have it. The ayes have it, and the amendment is agreed to. Are there other amendments? Ms. McCollum.
That's why raise your hand for a recorded vote.
A recorded vote is requested, although not timely received. And we'll go ahead and call the roll, but next time, ask it immediately. Clerk will call the roll.
Mr. Adderholt. Aye. Mr. Adderholt, aye. Mr. Alexander. Mr. Bishop. Mr. Bishop, aye. Mr. Bonner. Mr. Calvert. Mr. Calvert, aye. Mr. Carter. Mr. Carter, aye. Mr. Cole. Mr. Cole, aye. Mr. Crenshaw. Mr. Crenshaw, aye. Mr. Cuellar. Mr. Cuellar, aye. Mr. Culberson. Mr. Culberson, aye. Ms. DeLauro.
No.
Ms. DeLauro, no. Mr. Dent. Mr. Dent, aye. Mr. Diaz-Balart. Mr. Diaz-Balart, aye. Mr. Farr. Mr. Farr, no. Mr. Fattah. No. Mr. Fattah, no. Mr. Fleischman. Mr. Fleischman, aye. Mr. Fortenberry. Mr. Fortenberry, aye. Mr. Frelinghuysen. Mr. Frelinghuysen, aye. Ms. Granger. Ms. Granger, aye. Mr. Graves. Aye. Mr. Graves, aye. Dr. Harris. Dr. Harris, aye. Ms. Herrera Butler. Mr. Honda. Mr. Joyce. Mr. Joyce, aye. Ms. Capter. Ms. Capter, no. Mr. Kingston. Mr. Kingston, aye. Mr. Latham. Mr. Latham, aye. Ms. Lee. Ms. Lee, no. Mrs. Lowy. No. Mrs. Lowy, no. Ms. McCollum. No. Ms. McCollum, no. Mr. Moran.
No.
Mr. Moran, no. Mr. Nunnally. Aye. Mr. Nunnally, aye. Mr. Owens. Aye. Mr. Owens, aye. Mr. Pastor. Mr. Pastor, no. Ms. Pingree. No. Ms. Pingree, no. Mr. Price. No. Mr. Price, no. Mr. Quigley. Mr. Quigley, aye. Mr. Rogers. Mr. Rogers, aye. Mr. Rooney. Mr. Rooney, aye. Ms. Roybal Allard. Ms. Roybal Allard, no. Mr. Ryan. Mr. Ryan, no. Mr. Schiff. Mr. Schiff, no. Mr. Serrano. Mr. Serrano, no. Mr. Simpson. Mr. Simpson, aye. Mr. Valadeo. Mr. Valadeo, aye. Mr. Visklowski. Ms. Wasserman Schultz. Ms. Wasserman Schultz, no. Mr. Wolf. Mr. Wolf, aye. Mr. Womack. Mr. Womack, aye. Mr. Yoder. Mr. Yoder, aye. Mr. Young.
Are there members who are not recorded?
Mr. Alexander is not recorded.
Mr. Bonner.
Mr. Alexander, aye. Mr. Bonner is not recorded. Mr. Bonner, aye.
Are there members who are not recorded?
Mr. Visklowski, no.
Anyone wish to change their vote? Clerk will tally. On this vote, the yeas are 31, the nays are 17. The amendment is agreed to.